So a CVL is a creditors voluntary liquidation that is commenced by the directors and the shareholders. They can go down two different routes. It's a deemed consent route or a decision procedure. Whichever option is adopted, they both move very, very quickly because only 3 business days notice as a minimum is required. Now, a decision procedure is advertised in the London Gazette, and it is the calling of a virtual meeting where you can attend as a creditor and ask questions of the director. A deemed consent, on the other hand, is the process where the liquidator with the company is telling you that the liquidation is going to happen on such and such a date, and unless you object, the liquidation will happen and proceed. So in order for you to object, you need to have 10% of creditors' support. If you can do that, then you can requisition a meeting where you get the chance to ask those questions and perhaps appoint your own choice of insolvency practitioner. The benefits of attending such a meeting is going to be to ask the directors the question of the company's demise, and perhaps when should they have ceased to trade. So perhaps wrongful trading claims as well can also be explored. What you should remember though is you can just pick up the phone to an insolvency practitioner and call them to find out a bit more information. The key documents you need to be looking out for before a liquidation commences is the SIP6 report. That gives you the details of the company's demise, the financial history, and the statement of affairs. Now, the statement of affairs is the company's assets and liabilities as a book value in a certain point in time, together with quite a key ingredient, which is the estimated to realise figure. So, i.e. what these assets could reach as an asset realisation in the current marketplace. So as long as you're able to look at these documents, you're then able to make a decision on whether further questions need asking and what potential dividend returns you could achieve. If you're unsure on any of the documents you receive, by all means, reach out to a trusted insolvency practitioner to give you the appropriate advice.